Good evening and welcome to Introduction to Healthcare Law and Ethics, or Medical Law and Ethics as otherwise called. We want to quickly try and finish the second installment of our discussion of doctor-patient relationship. Just pardon me for my low voice because I am dealing with a cold. Yeah, so sorry about that. Yeah, yeah. So we discuss the ethical aspects of doctor-patient relationship at some length. We would like to continue by looking at some legal aspects, and we come back to how the interaction between the ethical and then the legal aspects of the relationship have actually played out in the law courts from time to time. Now, when we are done with looking at the doctor-patient relationship, we shall focus our attention to the relationship between other healthcare professionals and the patient, particularly pharmacists and the patient, the nurses and patients, before we wind up tonight. So we should appreciate that the doctor-patient relationship is not grounded only in ethical responsibilities or ethical duties actually map out by the various ethical frameworks for the doctor. But also, we have a more robust legal framework now, which actually governs the relationship. So, if for nothing at all, in Ghana, we can point to two things. We can point to Chapter 5 of the Constitution, fundamental human rights and freedoms, which in some of the rights enshrined in the Constitution uh, ultimately seek to protect the patient. And, and quite apart from that, we have a more tailor made or context specific legal articulation of the rights and duties of these stakeholders in the doctor-patient relationship. So in 2012, we had what we call the Public Health Act, Act 851, which was passed by Parliament. It's one of the voluminous pieces of legislation in the sense that it transcends various areas of the law, not only public health. So the name which is given to it may be a bit misleading. There are also aspects which are not strictly public health, so to say. So it is important for us to understand the legal dimension which has been added to this relationship. And that is important because it will enable us to appreciate how we can have a healthcare environment that respects patients' autonomy, trusts, and ensure that both doctors and patients adhere to defined standards of conduct. So let us keep that in mind. So if we look at the Public Health Act 2012, there's a provision, section 167, all that it says there essentially is to make a reference to the C schedule and says that uh, no patients are entitled to enjoy the rights and doctors are supposed to observe the duties and obligations contained in the patient charter. So section 167 will make reference to the C schedule. And the C schedule, which is the patient charter, is not something completely new. Those who are familiar with the subject will tell you that I think as far back as 2002, thereabout, or the beginning of the millennium, we had the Ghana Health Service championing the need to safeguard patients' rights and ensure responsible and ethical conduct in a clinical setting. So this resulted in causing to be published openly in many health facilities, what we call the patient's charter. But that did not have a legal footing. It was just a statement of a good practice, which is encouraged, but it could not bite. It could not bite in the sense that if it was not adhered to, you could not readily go to a court of law to seek a redress. And that is why it was quite welcoming when the lawmakers in passing the Public Health Act. And in fact, I must commend my brother, Dr. Divine Bayubula, who played an important role trying to ensure that they brought in all these charter in order to give it like a legal footing. So that is a very good thing. And I think the Medical and Dental Council could not have had a better person to be the registrar from my assessment of the Ghanaian situation than Dr. Divine Bayobula. So if you look at this charter, the patient charter and the C schedule of the Public Health Act, you will notice that it provides a very clear framework for patient care in terms of quality, autonomy, and safety. And at the same time, it recognizes that rights go with responsibility. So much as the lawmaker has recognized certain rights to be enjoyed by the patient is also reminded that you also have a duty or you have a responsibility to also live up to. So if we look at the charter, a number of patient rights are there. So with respect to quality and accessibility, the charter guarantees all patients the right to basic health services, irrespective of geographical location. And the idea is to promote equity in healthcare. And of course, you ask yourself, based upon what we learned in health and human rights, when we discuss the Hoffedian rights, Hoffedian analysis of rights, the fact that if it is a claim right, there should be a corresponding duty bearer. So therefore, if you say that patients have the right to basic healthcare services, irrespective of geographical location, of course, we will expect the state to be the duty bearer in this particular respect. Then the charter will also talk about what we call informed consent and full disclosure. The fact that patients are entitled to detailed information about their medical condition. You have to tell them in truth what their rare situation is. Available treatments, potential risk, the exception being emergencies where immediate treatment is required. For example, doctors will tell us that when it comes to conditions like stroke, sometimes time is of the essence as whether it will get worse, or the person can avoid any complication. So therefore, you will not have the luxury of time to actually make all the requisite disclosures. But of course, patients also have the right to know alternative treatment options, as well as identity of those providing the care, including students and other ancillary relief. So if you have a facility where, excuse me, if you have a facility where you have maybe medical students or nursing students or pharmacy students, and you need to bring them as part of their clinical activities within the context of the patient charter in terms of section 167 of the Public Health Act. You need to let the patient know that yes, you have students in the team which is going to care for him or her, and you hope he or she does not mind. If the patient says that I mind, that is, I object, you have to respect that and exclude the students. But I'm sure that we often take it for granted in our country. And I don't think the practitioners among us will be living up to that expectation. Practitioners, have you had occasions where you have pharmacy students, medical students, or nursing students, or some other allied health professional students working with you when you have to attend to patients? Anybody? Anybody? Okay, that's fine. We probably don't work in the teaching hospitals over there. It's a bit common.
Those mics were muted.
Oh, okay.
They were muted.
Right. Oh, all right. Okay, so let's hear you.
Yes, so this is Rebecca.
Rebecca,
We
okay.
always have students around us when we work because they are also learning and they are supposed to work under supervision. So we carry out procedures and they are there.
But Rebecca, let me find out. Do you, in terms of what the patient charter say, have you ever bothered to tell the patient that, oh, madam or sir, we have some students with us who are learning. I hope you don't mind. Have you ever bothered to make such an inquiry?
Unfortunately, we are supposed to do, but I cannot say that we do it every time or 100%. We are doing it 100% to be realistic.
Right.
But we need to do it. But sometimes we may have excuses that the busy schedules or work constraints. You can't keep on explaining to each and every client that I'm coming to perform a procedure. There's a student beside me. It depends on the situation. Emergency situation, we may not have all the luxury of time to be doing that.
Right.
But it's something that we know that we are supposed to do.
Right. Yeah.
Hello.
Yeah. Yes.
Hello,
Yes.
this is Cecilia.
Cecilia, yes.
Yes, Cecilia Senior. Yes, I'm also a pharmacist.
Right.
From what Rebecca just said, I remember during my internship for the ward rounds that we were going with the doctors and the consultants. What she's saying holds true, if I may be excused with the word. Some clients who are not kind of people that we can easily trample upon. But usually when we enter the private ward, the consultant made sure he informed the patient on admission before we entered, and then we were taken through the
medical conditions and all those. But for those in the normal wards, I think what Rebecca said holds, which, I mean, we are all at fault. But for those who kind of, I mean, have their money, they are in their private rooms and they're in their private wards, permission is sought before we were made to join the consultant for the ward runs. Thank you.
Right. Thank you, Cecilia. Good. The charter also talks about research participation, the fact that patients have the right to be fully informed before consenting to participate in research studies, and are also free to withdraw at any stage without compromising their standard of care. So it may well be that a particular treatment, a drug or procedure or whatever, they are still doing trials or some research, or they are gathering certain data, some patient experiences and so on. And the patient opted in to be part. Of course, he or she should have had everything explained to him or her before consenting. Now, in the course of the research, if the patient, for example, has a change of mind and say that, well, I'm no longer interested, I want to pull out, that should be respected. Again, we have, but the fact that the patient has withdrawn does not also mean that you are going to be angry with the patient and just reduce the quality of the care you are giving to the patient. No, you shouldn't punish the patient for pulling out of the research which is going on or you are doing. Again, confidentiality is also protected by the charter, and it seeks to protect the patient's private health information from disclosure without consent, unless required by law or in case of public interest. So it's confidential to be learned as a topic on its own. And I'm sure you've also learned it in the other modules as well, so we will not belabor the point. Again, under the charter, it is a requirement that patients are assisted to understand hospital policies, the fees system over there, and any complaint resolution procedures. These should be made known to the patient. If the patient, for example, want to find out anything, he should be told. And there's supposed to be transparency and accountability so that when people go to facilities, they should feel very safe, welcome, and they should feel at home, as it were. Again, second opinion. Within the charter, the patient charter, which is a law now, patients can seek a second medical opinion if desired. And this is supposed to support informed decision making. So Dr. A has told you about a particular diagnosis and then the treatment options out there, as well as the prognosis. But excuse me, but you feel, you don't feel too comfortable and you like to be really sure as to whether Dr. A is being very accurate and very reliable. So you want to go to Dr. B or Dr. C. So that is the second opinion we are talking about. So you should not be forced to submit to a particular procedure just because, no, that will be undermining your right to informed consent. Because informed consent, informed decision making is you being given the requisite information necessary for you as a patient to be able to make up your mind regarding accepting or rejecting a proposed procedure as the case may be.
Please.
Yeah.
About the second opinion.
Yes, opinion.
That the doctors in the various consulting rooms will have to inform the patients they are seeing that maybe, okay, I've attended to you, this is what your labs or whatever complaint you got is saying that you have ABCD. these are medications that are going to, but if you are not convinced, you can go to the next consultant or to seek for another opinion. Are the doctors supposed to tell the client that?
Well, I wouldn't say they are supposed to tell the client that, but if the client, for example, shows interest, that yes, I'd like to get a second opinion before we go ahead with what you have proposed, it should not come as an offense to the doctor who is attending to him or her. It's not a requirement for the doctor to tell him that go and seek an opinion, but then where the patient elects to seek a second opinion, that should not be. Yes, yes.
Okay.
Yeah. Because as we have indicated, patients also have a responsibility. You have the duty to be, to make honest disclosure. You go to a hospital, you have to provide accurate medical history and information. And this is essential for accurate diagnosis, treatment, and effective healthcare delivery. You are a patient, you are there. The doctor is not a magician. The doctor is not a magician. And there are yes. Yes.
Good evening.
Good evening.
I'd like to know whether the patient charter. I would like to throw more light on the patient charter, because sometimes some patients, when they come to the hospital, some of them, they know their, let me say, their rights. Let me say it that way. But some, they refuse to know their responsibilities as well. So throw more light on the patient charter. Thank you.
If we say like throw more light, you mean you want to see the provisions or the explanation? If you can help me. Do you have the Public Health Act, please? You have it from the other model, don't you? Do you have it as we share with you?
Please share.
All right, okay. All right, so
I would like to know more about it. Is it some kind of a law?
Oh, right. Okay, good.
What does it entail?
So I have made the point not long ago that what we call the patient charter, it started initially not as a law. So for a long time, it was talked about, published in so many places in the health facilities. Then in 2012, when they were passing the Public Health Act, they managed to get it included in the law so that it's no longer just a statement of a good practice, but it is a legal requirement. So that is the difference we should note. So the patient charter is not a statement of a good practice since 2012. Before 2012, yes, you could treat it as a statement of a good practice and so on. But with the passage of the Act 851, that's the Public Health Act, in 2012, is no longer a statement of a good practice. It is a statement of the legal position. And it is the law that the rights which have been stated in the charter should be respected. The duties which have been stated in the charter should be respected. And again, where there is a breach, you can enforce it in a court of law. You can enforce it in a court of law either as a cause of action in its own right, as you, for example, enforce any other statutory provision which creates a right for you, or if, for example, you need to mount with some form of medical malpractice suit, that could also be subsumed under it. So the important thing to note is that the patient charter is no longer just a statement of a good practice. It is a law because of the the Public Health Act of 2012, as we have been talking about, at 851. So let's keep that in mind. I will share the, yes. Yes, let's hear you.
Just please, okay. Honestly, until this evening, I'm not a practitioner. I'm a lawyer. But until this evening, I'm at a medical facility.
Okay.
Wife to a medical facility.
Okay.
Then the ward, just before in the ward, behind the door, I saw patients chatter.
Okay.
All along, I had the notion that maybe because of my law background, I know if you go to the hospital, you have your rights. But I didn't know of the responsibilities.
Oh, right. Okay.
They've done a brief, not everything, but I think the key areas.
Right.
In fact, going through it, when I looked at the responsibilities of the patient, will I be right that that is a shield to the facility in case a suit is brought against them? That I'm saying a shield because I read that it's your responsibility to disclose your full medical history. So if you do not disclose and something happened, can the facility rely on you failing to do your part?
Oh, all right. Okay. Thank you, Counsel. To start it, I wouldn't say that it is published as a preemptive defense mechanism on behalf of the facility, so that if something goes wrong and you sue them, they begin to flag it in your face that, but we told you, you told you this, we told you. No, not necessarily that. I think the way it is, if you don't go to hospital, there are a lot of things related to law and to the health which will not be of interest to you. But when you become a patient, then you become interested in those matters, as it were. And that is why those things are there. Now, for the duties, like, for example, the fact that you have to make a disclosure, the fact that you have to make a disclosure, if you don't make the disclosure, which you know about yourself. So let's give you a typical example. Let's suppose that you have a particular serious allergy, okay? A particular serious allergy. And maybe by reason of that allergy, maybe certain prescriptions are very dangerous, but you keep quiet about it. You keep quiet about it, and you are giving certain medication, which ultimately worsens your condition. Now, later on, you cannot be held to be bringing a suit, saying that, oh, but why did you give me this medication when I have this condition? And according to state of medical knowledge, if you have this, certainly you must not have that. Now, you kept quiet over your situation. And because you kept quiet over your situation, you deprived or prevented the facility from having accurate medical history. And mind you, allergy, like for example, a patient goes to a facility, in the usual scheme of things, the doctor should not be suspecting any allergy. I don't think that would be, initial line of investigation. So, if you know it already about yourself, you have a duty to make it known, and that is why some people will even be carrying certain, critical health information in their purse or on themselves, so that should it become necessary, no mistake will be made. Again, as part of your responsibility too, you have to adhere to prescribed treatment. Treatment have been prescribed, medication or certain therapies have been prescribed for you. you have to stick to them. If there are adverse effects, you have to report them. And then if you are supposed to do follow-up, you have a responsibility to do that. If you don't do the follow-up and later on, something goes wrong and you sue for, let's say, clinical negligence. When we are talking about, let's say, causation, for example, and then what we call the contributory negligence, it may well be that the doctor or the facility breached its duty of care by not doing its work well. That is fine. But then it may also be the case that because you did not comply with the follow-up, if you are given a certain timeline to come back to the hospital for follow-up investigation and so on, you didn't do that. And let's say that you waited 1.5 months later before coming, and things have actually gone wrong. So here, you have also contributed towards whatever problem that has occurred. So the patient charter said that you have a duty to adhere to treatment, any follow-up requests, and so on. There was a case, for example, it involved confidentiality. I think I discussed it in my book, Medical Law, the Primer or something. And not confidentiality involves the Kolebu. And one young man, I think he has gone there for a surgery, and then they ended up, carrying out the surgery on the wrong leg, which has not got any problem. And I think he had a bit of like a football, career ambition and so on. So he also got the media to be following the story, and then the Kolebu people got angry. So when he had to go on the follow-up, they were reluctant to actually treat him because he had gone out to, as it were, to blow the whistle, as it were. Of course, patients are supposed to be treated with respect and dignity. In the same way, patients are also encouraged by the Charter to respect healthcare staff and other patients, as well as the property of the facility. So if you're a patient, you don't have to disrespect healthcare professionals or other patients as well. And this is a duty that we bear. And again, the Charter also encourages patients to engage in preventive and promotive health practices. So we can say that the Charter serves as a both legal and ethical guideline, seeking to strike a balance between patient autonomy and also responsibilities required for effective and respectful healthcare interactions. Now, let's say a few words about this particular aspect of the doctor-patient relationship, the issue of trust, and also this fiduciary duty. Now, we need to discuss this because you've had rare life case situations in the case law in which the courts have had to grapple with whether the doctor is a fiduciary or not a fiduciary. The level of trust, between the patient and the doctor in this relationship, does it actually rise up to the level where we can say that the doctor is a fiduciary? So that is what we want to be discussing. And it is important because if you say that the doctor is a fiduciary, then what you know about fiduciary law will apply to doctors in a doctor-patient relationship. So let's look at the case of Nobage against Winrib. It's a case from the Canadian Supreme Court. Now, the Canadian court took the view that the relationship between doctor and patient is one of fiduciary. And for that matter, the doctor has an obligation to give priority to the patient's interests. Just as like those who know fiduciary obligation, let's say between agent and principal, or between directors and companies and so on, that they have a fiduciary obligation and they are supposed to avoid the conflict of interest. They're supposed to make all disclosures to the principal and give priority to the interests of the person that they owe fiduciary obligation towards. Now, if you look at the Nobek against the Winrib, it was a case which actually involved, like sexual exploitation by the doctor, because the patient was, vulnerable. And if you look at the story, I discussed the story later on. I'll discuss the case later on in the course of the lecture. But we had a patient who needed a prescription drug, which something like a drug, is a drug patient and needed a certain prescription. Is a drug which cannot be given unless it's prescribed, and the doctor who is supposed to do that, having exceeded a certain dose, decided to elicit sexual favors before giving more of such prescription. So that was but we'll come and talk about the case pretty soon in the course of this lecture. So don't worry about that. Then we also have this problem of power imbalance and risk of exploitation. If you remember the Ian Kennedy's work on Marxing medicine in his BBC Riff lectures, he actually underscored that point, that if you look at the asymmetry of information between the doctor and the patient, there's that risk of exploitation because of the power imbalance. The doctor possesses specialized knowledge and authority, and that in itself creates the potential for what? The potential risk of exploitation. If you are sick, you are desperate, you are vulnerable. There's no doubt about that. Even if you are a medical consultant, you are a professor of a particular subspecialty of medicine, and you are sick, you're a patient. Once you become a patient, it doesn't matter your background, you are a patient and you are vulnerable. So when we are talking about these issues of vulnerability, don't let us use this approach, they and us. No, all of us are potential patients. So we are looking at when you are in that situation as a patient, the vulnerability, and for that matter, you becoming desperate and susceptible or amenable to exploitation. Those are the things. Yes, you've seen the AA answer and then the JS. Let's hear you.
Doc, good evening. I'm Apikino Albert.
Good evening.
Yeah, so I would want clarification on this, Prof, that the chapter one, a decent life. But then if maybe as a medical doctor, I go to a sitting and a client or the committee finds me with an alcohol in front of me, does it contravene or is it against my charter and the ethical issues around it? Thank you.
Now, the alcohol, was it in the clinic or at the social place?
Please, sir.
Maybe like a party or something, or at the drinking bar?
Yes, please.
Okay, good. Well, the doctor is a normal human being, but sometimes, and that is why we say that ethics, goes, higher than law. It is not against the law for you to be drinking, so long as you don't do drink driving, either at the parties or funerals or whatever. But let's suppose you are a doctor and you have patients within the community, and you have been telling your patients to stop drinking alcohol so that they will reduce their risk of cardiovascular disease and liver damage and so on. And you are seen drinking generously, drinking heavily. It's not against the law, but it weakens your moral and professional authority. If next day the patient is sitting before you and you tell him or her that you think that if he stop alcohol or if he drastically cut down alcohol, it will do a lot of good to his or her health. Yeah, so doc, it's not so much the law forbidding it, but it's a question of you using what you call like the good judgment. Just like if you are a judge, we don't have our code saying that you can't do a lot of things, but all the time you must judge for yourself. That even if the law does not do that, because of your standing in society and then the work that you do, is it prudent? Is it appropriate? And so on. So for us, we don't have too many friends, for example, because you want to minimize the risks of you being conflicted in a lot of cases which come before you. So you will have to police yourself and not anybody. Okay, doc? Does that help you?
Yes, bro.
Yeah.
I'm looking at the situation. We are social beings and culturally to be part of the society in terms of this social gathering. And sometimes you may go back to your roots, you are there. So,
Right. Yeah, so as I said, all the time, you have to be mindful of the dignity of the profession you also belong to. So you also owe the profession a duty not to run down the dignity of that profession into disrepute. So you ask yourself, this thing I'm doing, will it reflect fairly on the image of the profession that I belong to? JS, is your hand up?
No.
All right. Okay, Damien.
yes, my lord. So, as a doctor, I advise to take some patients. I think that's a big worry because I may not have the same health issue with the patient. Just that I know I have to conduct myself important so well. I'm not in the patient coming to my private life and then trying to infringe on my rights.
I think the line went down a little bit. Can you repeat yourself, please?
what I mean is that I advise a patient to be probably having a cholesterol and I advise you to drink an alcohol.
Yes.
And you see me probably in a gathering and I'm drinking an alcohol.
Okay. And yes, you can continue. Damien, please continue. Okay, I think we've lost him. Of course, there's no legal obligation or for you, the doctor, to put example how you live after working in the clinic. But as I said, uh, the ethics of your profession, and if you are someone who values your profession, you may want to live beyond reproach so that you don't run your profession into disrepute. That is the point I was trying to make. There are other examples from the cases where there have been exploitation. Look at the case of Moore and Regent of the University of California. That case, the Supreme Court of California examined the case of a doctor who used a patient's cell for research without the patient's informed consent. And this clearly brought about the issue of exploitation and consent. Now, the doctor had financial interests in the patient's unique cells, and this actually amounted to a conflict between the doctor's fiduciary duty and the personal gain. So the personal gain is the money he was making for making these unique cells available for research. But the fiduciary duty was to let the patient know what exactly was going to occur or happen to his or her cells, as the case may be. And the court ruled that doctors must disclose any interests that could influence their professional judgment, especially so where such interests could lead to patient exploitation. And this, I think pharmacists are also to be blamed here, particularly. No, of course, some doctors are also supposed to be blamed. They go and get some of these big pharmaceutical companies. They have drugs and they would like their drugs to be prescribed all the time. Despite the fact that there may be better or some other equally drugs available, because maybe the doctor or the pharmacist has been promised a certain commission, then they'll keep on forcing it down their patient. So does that happen? Does that happen?
Yes, it happens a lot. And most of the times to
All right.
most of the times when there are seminars who see their disclaimers,
Right.
but then they sponsor most of these workshops and training. And eventually they will have the farm companies will have drug rate coming to also advertise on this. They are no interest in it.
Okay. All right. Yes, and it, yes, yes.
If I may,
Yes, please do.
I am of the opinion that there's a pharmaceutical marketing code which was developed in tandem with the FDA, but been enforced for as long as I can recall. So, I mean, in a human society, obviously, there are people who run businesses with the sole aim of making profit. So you have these issues happening. But there are clear guidelines in the marketing code to regulate this. in other jurisdictions, you realize that in situations where pharma companies have been complicit in some of these things, states is able to sue them, and in instances where people have been able to bring class actions. So I think that, it depends on the jurisdiction and how stringent citizens are, one, and then also how deliberate the state is in managing some of these things. Thank you.
Right, thank you. And another aspect of this same program is also to do with the springing up of these private laboratories and then ultrasound centers. Then you go to a doctor and you are referred to a particular laboratory, a particular place to go and take your scan or X-ray because of maybe some financial arrangements between the doctor and that particular private facility. You are referred there, and sometimes some of the investigation may even not be very necessary, and the doctor can even do without it. But because if you go there, you pay money, and the more he or she makes a referral there, then he's making more points at that facility, and then he'll get more commission. Is that the case? Does that happen?
Yes, they don't.
Yeah, good.
One of the most bizarre part is when the doctors prescribe brand drugs
Okay.
instead of generic drugs. Situation, they will prescribe a particular brand. And those are always the things that influence it. Instead of the generic, you will struggle and you have to go to that particular place to get it. When trauma, even later that can do the same thing, but even far better. This is Charles.
My Lord Reginald again. I have a different opinion.
Okay.
I have a different opinion. So I agree that to a large extent that doctors or pharmacists are able to make choice. I mean, by way of disclosure, just so that by way of disclosure,
yes,
I agree that doctors or pharmacists are able to make decisions to prescribe specific drugs, whether it's innovator. But I don't agree about the point concerning what informs the choice of an innovator drug. There could be individuals who are induced to make those decisions, but there are instances where, based on experiences of the clinicians, in this case, whether it's the doctor, whether it's the pharmacist, their experiences and the evidence they have, they would recommend certain brands over the other. For instance, a patient has been transferred, say, from Cape Coast to Accra, and this is a life-threatening situation where the patient has to be taken to an ICU or an HDU. There's an innovator available, the family can afford, and then it's a generic. I think this is a matter of life and death. If affordability is not an issue, the decision becomes pretty straightforward. But in situations where the family cannot afford, and that is where the team needs to disclose or make available options to the family or the patient for them to be able to make a decision. So I think there are a lot of nuances that, on face value, it's easy to say that people would easily go for the innovator, but there are a lot of undercurrents that informs that decision. And if we were in that situation, as patients, we would always potentially go for the, so to speak, expensive option, because you don't want to do what maybe the guns will say, with someone's life at that instance. So these are my only dissenting opinion, but I broadly earlier remarks. Thank you.
All right, thank you. Yeah.
No, good evening.
Good evening.
I also opinion about this. In terms of the innovator drug, okay, so as a friend of I'm also a medic. And the practice has been that once you are in the government institution or the private one, you make the options available to the client. We cannot just look at the appear on the appearance that this my client can afford this drug or cannot afford this drug. So you make it available to them that this is how it works. We have another brand, this is how it works. And this is their efficacy. So you have to give them informed, let them make the informed decision. The information has to be clear to them so that they can make the information by themselves. So that when you don't assume that, oh, somebody, excuse me, who is in a chartered attire cannot afford a drug that will work magic on him in a matter of hours or days. But then you should make it available to them that these are the options, this is what we are going for, this is our end game. Then they make their own decision. But to force the branded drugs on them is a problem. For all you know, the generic ones might also work perfectly for them. But maybe because of the commission that is attached to some of these drugs, then we try to force them on our patients. I think that's what mostly occurs in the hospitals. Thank you.
Thank you. Yeah. So yes.
So this is Cecilia. If I may also add.
Yes.
I think I share in the opinions which have been expressed by both my colleague pharmacist and then my other colleague medical officer. From what we all know, a drug, paracetamol, if we say paracetamol 500 milligrams, regardless of where it's coming from, to contain the required active ingredients. So whether it's coming from the innovator or it's coming from any other pharmaceutical company who is been accredited to, come up with any generic products. But the question is, from experience, are they giving the same results? All of us health workers here should answer for ourselves. Secondly, in the public sector, public facilities, we are even not supposed to prescribe branded products. And so I'm not going to argue that, we have promoters coming around and then we have them sponsoring most of these programs. But if we are working in the private sector, we to prescribe only generics. When there is a referral or there are instances where we need to go for the innovator brand and we have generics and we have other brands, I think our professionals here will bear with us that the innovator brands, are giving us the perfect results compared to the generics and then compared to the other products. So if we are saying that they should contain the same active ingredient, why are we having these results or these outcomes from these two products? And so in the public sector, we are going by the generics. And so if you are writing a branded product, that means you are writing it for the client to pay and not for me to assess it with either the health insurance. But I'm not going to dispute the fact that, some of us have other, how do you call it, private businesses or whatever, or other interests that to some of these things. But if we are going by what we are, asked to do, then I think the innovator brands and then these generics usually do not come in. We need to go for what works. And I think that is what we mostly do. Thank you.
Right. Thank you very much. Yes, I appreciate. David.
Yes, my Lord. So I want to speak in relation to what my sister just said. About the effectiveness of a medicine. We all know, we say paracetamol 500. It should contain the same 500 milligram as the innovator and the generic. The innovator, he's the of the acting.
Yeah, I think we've lost him, but I think we've discussed the issue enough. Let's continue. Yeah, so I was citing how the Canadian courts view the doctor-patient relationship, and they view it as one of fiduciary nature. And we cited the case of Norbech against Wainwright. Lawyer Laura Norbech, a lady, a patient, struggled with the addiction to painkillers. So she sought treatment from Dr. Wainwright. And instead of providing appropriate medical care, Dr. Wainwright exploited her vulnerability and agreed to supply her with drugs in exchange for sexual favors. So anytime, those, the doctors, those who have the addiction syndrome, there are times, that the, the appetite or the trigger will come, and then they need to actually get the drug so that they will stable. So anytime she needed the drug, the doctor will have to have the sexual favors from her, and then will give the drug to her. Because as I said, the drug is a prescription drug, and it's only a doctor who can prescribe it. So this went on for a long time, and eventually, Norbert brought legal action against the doctor. And as we have seen already, the court actually found in favor of Norbert, that is the patient, and to the view that Dr. Wainwright had breached his fiduciary duty to her. So we'd like to look at some key aspects of the decision, especially the fact that there's a fiduciary duty in the doctor-patient relationship. And with respect to that, the court made the point that when we say that the doctor-patient relationship is one of fiduciary, it actually means that doctors have a duty to act in the best interest of their patients. So, consistent with fiduciary relationship, one party, in this particular case, the doctor, has power over another. And who is the other? The patient. And that creates a duty of care, loyalty, and trust. And the court also viewed that this duty is particularly strong when the patient is in a vulnerable position, as was the case with Laura Norbech due to her addiction. So she should definitely do anything you ask her to do so that she could get the drug in order to become better with her addiction tendencies, as it were. And this also happens in a parts of the world. For example, even when it comes to sometimes even clinical abortion, we have some doctors who ask for sexual favors before they will do it. Or when it comes to some other things, it may not be a large scale development. It may just be isolated cases. But we are learning, so we discuss everything, both the isolated cases of inappropriate practices and also the pervasive one. So we are not saying that it's on a larger scale, but we are just learning. So we need to talk about everything. And it goes without saying that what the doctor did clearly was a violation of his fiduciary duty. And as you know, he used his position of power to exploit Norbert's dependency on medication for personal gain. So the personal gain on this occasion, unlike the Moore and the Regent University case, it's not financial. This one is, if you like, non-financial, emotional, sexual, as it were. Does that occur in your clinical experiences? Okay, that doesn't occur. Okay, that is fine. We are not being bad in Ghana.
So the point is, until the issue comes up,
yeah,
you wouldn't know whether it is happening or it's not happening, because there are some few occasions few cases that we've heard that doctors or prescribers take advantage of their clients when they meet them in the consulting room and all that. But sometimes it's the ability of the client to come out, talk about it, and get what do you call it? Legal, whatever. That you hear about it. Otherwise, and then sometimes to, I don't know whether it's fear or intimidation or timidity, I don't know. So they, even though they might be suffering those things, they will not talk about it. So we can't say that they are entirely not happening. They might be happening, but until we hear about it, we say that we are good to go.
Right. That's Regina. Thank you. Yeah. Now, with respect to the exploitation, the doctor seemed to be putting up the argument of consent. So Dr. Monrep argued that the patient, Norbert, had consented to the arrangement and that he never forced the patient. And I want you to pay attention to that aspect well. Now, the court rejected his defense that the patient had consented to the arrangement, that, yes, if I will give you more prescription, then you also have to extend those sexual favors to me. Now, the court rejected the defense argument, the consent argument, and noted that Norbert's so-called consent, the so-called consent given by the patient, was not valid due to the power imbalance and her dependency on the doctor for her medication. Because the facts clearly showed that this was a serious addict who needed the medication desperately, that she would do any thing which you ask for so that she will get the medication. So therefore, if she did it, the court was saying that we cannot say that her consent was a genuine consent. So it was a court view that true consent must be given freely without coercion. And in this context, Norbert's reliance on the patient's reliance on Dr. Wonrep for access to medication effectively nullify her ability to give a genuine consent. Now, this is very significant from the point of view of looking at the doctor-patient relationship from the fiduciary relationship. Now, when the Canadian Supreme Court chose to characterize the doctor-patient relationship as a fiduciary, it set an important precedent for medical law in Canada. And this fiduciary classification of the doctor-patient relationship means that doctors are legally obligated to give priority to the welfare of their patients above their own interests, even more strictly than in a typical professional relationship. In most professional relationships, it's not really required that you give priority to the interests of your client over and above your own, except that you may not have to hurt the interests of your client. I give you a typical example. When it comes to lawyers, okay, when it comes to the lawyer-client relationship, for example, if you read the legal profession act and you read the rules and etiquettes of the legal profession, you are told that as a lawyer, you are an officer of the court. And for that matter, you must be loyal to the court first in terms of the true position of the law before you even attend to the interests of your client. What it means is that if there's a law which hurts the case of your client, you are not supposed to mislead the court about that law. You have to be very honest and speak to that law, even if it's hurting the case of your client. So when we say that, but you are working for your client, so why will you not give priority to your client's interest? No, you're an officer of the court. So you have to, and the court is a court of law. So you have to work with the court for the law to be upheld, even if it hurts the interest of your client. But when it comes to the doctor-patient relationship, that you are supposed to treat it as one of fiduciary, then it raises the bar high for the doctors to give more priority to the interests of their patients. And here, we are going beyond technical competence to include ethical responsibility to protect and respect the patient's dignity, autonomy, and well-being. Now, in the UK, the courts for a long time resisted invitation to treat the doctor-patient relationship as one of fiduciary. I mean, the court recognized the fact that, yes, there's a significant trust-based nature of the doctor-patient relationship, but they do not recognize the general position as the Canadian court sought to do, that the doctor-patient relationship is one of fiduciary. So therefore, in the case of a Sidaway against the board of governors of the Bethlehem Royal Hospital and Mosley Hospital, a case we've mentioned before, and I'm sure you've read it. That case, an attempt was made to import some of these ideas from the other side of the Atlantic to English medical law. And Lord Scammon made the point that, yes, the relationship between the doctor and patient is a special one, no doubt about that. It does not fit neatly into traditional fiduciary relationship like between solicitor and a client, or trustee and beneficiary, as it were. What happened in Sidaway case? Mrs. Amidori Sidaway suffered from persistent pain in her neck, her right shoulder, and arms. After conservative treatments failed, she was referred to Murray Farconer, that is a neurosurgeon. I'm sure in medicine, if you are called Mr., it means you've really attained a height of your profession. So this is a Mr. Farconer. But I think Ghana, the tradition is different. They like professors and the rest. But I think if you go to Europe, and if we say someone is like a Mr., it means that he's really reached a very high level in the profession. So this was a neurosurgeon at the Mosley Hospital. And Mr. Farconer recommended cervical cord decompression surgery to alleviate the symptoms that Mrs. Sidaway had complained of. So Mr. Farconer, that is a neurosurgeon, obtained the consent of Mrs. Sidaway for the procedure, but did not inform her of the risk involved in the procedure. And the risk was estimated at less than 1%. So not exactly 1%, but something less than 1% chance of developing paraplegia as a complication. So there was that chance of that paraplegia complication developing, but the chance of it occurring was less than 1%. And for that reason, Mr. Farconer, the neurosurgeon, did not probably consider it significant to tell Mrs. Sadawi about it before the procedure was done. Unfortunately, Mrs. Sadawi developed, as the book of Job said, what I have heard has come upon me. So what she feared, of course, she didn't know. So she developed the paraplegia after the surgery. And doctors, what is paraplegia? Can you explain it for us? Yes.
It's paralysis of the lower parts of the body.
Okay.
Usually from maybe spinal injury or surgery or anything.
Oh, okay.
It's usually the lower parts, the lower limbs.
Oh, okay. Okay. All right. Thank you. Yeah. So,
And
yes.
maybe to add on,
Yeah.
it can lead to, or it can affect one's bladder or your bowel control as well as a consequence.
Oh, okay.
But it depends on the extent of injury on
Okay.
the spine.
Okay. Okay. So that was the situation which, unfortunately, Mrs. Sedawi found herself in after the surgery. So she brought a case, a claim against the hospital, and Mr. Farquhar. He sued both the physician and then the hospital because of vicarious liability and alleged negligence due to the failure to disclose the risks of such a serious complication. So her problem was that if I had been told that there was this chance of me getting the paraplegia, I would probably not have consented to the procedure and have gone without it. But here is a case I was not told, and I consented, and this is where I find myself. So that was her case, essentially about the failure to disclose. So the central legal issue was whether the surgeon's failure to inform Mrs. Sedawi of the small risks of the paraplegia constituted a breach of duty of care owed to her, and for that matter, rendering him liable for negligence. So the case also brought up the bigger question regarding the standard by which a doctor's duty to disclose risks should be assessed. Whether it should be determined by the medical profession standards, as in the Bolam test, or by considering what a reasonable patient will want to know. So the case we call at the Bolam, which you mentioned before, and we mentioned it again, especially when we are discussing the model we call the medical negligence. Bolam case, 1957, McKnight J. in directing the jury, which had to determine, please put the mic off. Minute or two by Nicholas Jackson, the lady from Chelsea. Oh, please, come on. When you are doing online, you must be disciplined about the background noise so that you don't distort the forum. Thank you. Yeah, so the court held eventually that, of course, there was a split decision, but the majority held that Mrs. Sidawi's appeal should be dismissed. And the court had agreed with the High Court, which actually said that Mrs. Sidawi did not have a sustainable case, and she appealed. and the House of Law also actually threw the case away. And the court applied the Bolam test from the Bolam case to the effect that a medical professional is not negligent if their conduct aligns with a practice accepted as a proper by a reasonable body of medical opinion. So the majority, of the panel of the House of Laws held that the surgeon's non-disclosure of the rare risk, rare risk in the sense that the chance of it occurring was less than 1% of the paraplegia was consistent with accepted medical practice at the time, and therefore did not constitute negligence. So the court look at, if we take other doctors, a reasonable body of other medical professionals, in the situation of Mr. Farconer, would they have considered it professionally prudent to tell the patient that there was less than 1% chance of this particular paraplegia complication occurring after a surgery of this type? And from the evidence, the answer was in the negative, for which reason the court said that then we could not blame the Mr. Farconer for his non-disclosure of this rare risks of paraplegia. And Lord Diplock, speaking for the majority in the Cedarwell case, will make the point that, quote, to decide what risks the existence of which a patient should be voluntarily warned, and the terms in which such warning, if any, should be given, is as much an exercise of professional skill and judgment as any other part of the doctor's comprehensive duty of care to the individual patient. And expert medical evidence on this matter should be treated in just the same way. The Bolam test should be applied. So that is how the majority actually rendered. There was a dissenting view. Just as this evening, one of you have dissented from the majority discussion. So there was a dissenting view by Lord Scarman. And in his dissenting view, he made the point that the Bolam test was not suitable for assessing adequacy of risk disclosure. In other words, it's not enough for you to find out what other doctors will have considered necessary to disclose or not to disclose before you make a determination as whether, in a particular case, the doctor can be held liable for having breached the duty of disclosure. And he contended that patients have a right to be informed of all inherent and material risks. And that in itself suggests that he was looking forward to what we call the patient-centric approach instead of doctor-centric approach. And this is how Lord Scarman rendered himself, quote, the duty to inform the patient is not merely a matter of professional practice, but of ensuring that the patient is fully aware of the risks involved, which is a fundamental aspect of informed consent, unquote. Now, before we move on, I ask you, do you think that it's necessary to disclose all potential risks, including even this example of less than 1% risks of a certain complication occurring before the patient gives his or her consent to a proposed treatment? Yeah, let's take about two views and then continue. Yes. EF, you can speak.
Yes, Your Lordship, I agree with the dissenting opinion because given the explanation that my colleagues have given concerning the disease, I think it was it would have been better if the doctor had informed the patient that even though it's rare, there's a possibility of it happening some way, somehow, and then she is fully aware of everything before consenting to go for the procedure. So I agree with the dissenting opinion. No matter how small or how minute or how rare it is, she should be informed of everything so that she takes a decision based on everything and then or not.
Right. Yes. Any other?
Yes, my lord.
Yes.
I've always had a problem with the Bolam test. I think that the courts, by that one decision, lowered the bar for informed consent. And consistently, they keep referring to it, even where the negligence is so huge. They will make the argument go round and say they use the Bolam test and then dismiss the case. If I am not informed, how do I give consent? And the court adopts a very barest minimum, even where in the medical profession there is no generally accepted, I don't know if I'm using the right word, standard in terms of application of that particular procedure. Even if peer colleagues in the field disagree with that particular method, still the court doesn't consider it just because they think that the practitioner doesn't owe the patient that duty. How do I give consent if I don't have adequate information? My understanding of informed consent is that you have put all the issues before me, and by my understanding of that, I said, okay, yes, I'm going along with it, or no, I am not going along with it. If I'm not well informed, how do I give consent?
Okay.
Well,
yes.
Well,
yes. Yes.
May I make a
Yes, proceed.
Most of the time, when we talk about information, I know the general position has been that information that you need must not be technical. It must be something general for you to understand. So that if I take the case that we just did, which was less than 1%, if you were to disclose to that patient, it was to be in general terms that will let the person appreciate it and not into that technical details. So sometimes when you find people come to you that I gave consent, I was not well informed about the consent, my first question to them is, at what point did you realize you were not well informed? Was it after you gave the consent? If yes, did you go back or the procedure was finished? Because if you say you were not well informed, is it that after you went to read something before you said you were not well informed? And these are practical things. So as I know, the court also looks at case by case, although looking at the standards. And like in that case you gave, most of the ruling has been that what happened was it the general accepted practice of the regulatory body that do not infringe on any right. If yes, the regulatory body allows for this level of information, and if that is given, then it suffices to be well informed. Thank you.
All right. Thank you. Good. But okay, let's see the last one. All right. Yes.
Milo, sorry for the interjection. I just have a preliminary point to make concerning the submissions made thus far. Okay. So the speaker made a point about he having some issues with the Bolam test, but I recall that there's been a case, I think sometime in 2015.
Yeah, Montgomery. We are coming to it very soon. Yes, we are coming to it. Yes.
So the Montgomery and then the land case. So, I mean, since we are going the parliament, I'll just have here. But just to add that if a patient you are seeing a patient in a community pharmacy and you are giving the patient, for instance, an anti-malaria, duty bound to make him aware that, for instance, maybe X anti-malaria do this or that way, or this drug may. So they are, even at that level, you are giving that information just for the patient, assuming he's even going to work on a for drive, just so that he knows that it will make him drowsy. So in the surgical cases and all that, or broadly speaking in medical cases, we may need to look at what is that minimum level of information required, just so that at least a patient can be well informed. But of course, that will be a spectrum and debatable depending on the case and then the individual we are looking at. So maybe because my Lord said we'll move to the Montgomery case, I'll leave it here.
Yes.
Thank you.
Yes, all right. Thank you. Yes. So subsequent development. So Sedaway, articulation of the law, as we saw, that if a reasonable body of a professional body would not have considered it necessary to make a disclosure, then nothing wrong has been done. That remained the position for a long time until 2015, when Montgomery against Lagnachere held board a case from the Scotland, eventually made it to the UK Supreme Court, was decided. And in Montgomery, there was a clear departure from the Bolam test. So the dissenting view of Lord Scarman, more or less, has become now the position of the law. So particularly when it comes to informed consent, Lord Scarman had advocated for a patient-centered, if you like, approach. That was rejected by the majority in the Sedaway quiz. In Montgomery, in 2015, more than almost 2 decades or so after Sedaway, they've come back to that. And Montgomery said that doctors are under duty to take reasonable care to ensure that patients are aware of any material risks involved in the proposed treatment and of reasonable alternatives. One of your colleagues, one of the ladies, made the point that she is interested in being told everything that needs to be known as far as the risks are concerned. However, insignificant it may be with respect to the chance of it occurring, he or she wants to know so that he or she can take a very responsible or informed decision as whether he really want to run that race or he doesn't want to run that race. Now, that viewpoint is what the House of Lords actually endorsed in Montgomery and Lagnachere, as we have stated. And there has been a greater emphasis on patient autonomy. And more importantly, for doctors to consider what information a reasonable patient would find significant. So it's not just for the doctor to say that, oh, from this one is something of a, doctors will say that was is clinically insignificant, and that's how they put it. So from maybe your technical point of view, oh, you say that, or these surgeries that we do, if you have to do about 1,000 surgery to get 1 or 2 deaths or failures occurring. So in that case, we consider this potential complication clinically insignificant. So we don't deem it necessary to tell the patient. Montgomery and Lagnache say that no, we need to find out if a reasonable patient will consider such disclosure, such information significant before he or she will give his consent. So we noticed that initially, of course, Canada had actually taken the viewpoint that the doctor-patient relationship is one of fiduciary, and UK was actually not forthcoming in categorically recognizing that until Montgomery, as it were. So what we gather from all this is that the doctor-patient relationship has been undergoing some significant evolution in the sense that originally, or for a long time, it was based upon a paradigm known as paternalism. Paternalism. Now there's been a paradigm shift from a doctor-patient relationship based upon paternalism towards what we call the collaborative patient-centered approach, collaborative partnership, what they call the therapeutic alliance, in the sense that it's no longer the case that, oh, you patient, you don't know anything in terms of the technical things, so leave everything to the doctor who has the technical knowledge and who is also supposed to seek to your welfare to make all necessary choices and decisions. And that will suffice. Now that has actually changed. And the focus now is more on the fact that it's a partnership between the patient and the doctor, as it were. So what are the key aspects of saying that the doctor-patient relationship is now patient-centered? So this will require that there's supposed to be more respect for autonomy. You have to respect the patient's autonomy when it comes to decision-making regarding their health. And this should be based upon a full understanding of the medical options. Patients should be told what the options are, rather than you just forcing only one particular option on the patient. Because ultimately, the patient will need to decide whether to embrace a particular proposal or not. So he or she needs to be given the option. And I like what one of you put it, that yes, the patient should be given information, not necessarily in the technical language, but in a language that the patient, as a layperson, can actually understand. I mean, that is what is important, and that is what the law really is. And doctors are supposed to communicate what they call like a balanced information. Balanced information in the sense that you don't have to force your preferred view on the patient. There's a way by which you can manipulate a person to buy into your viewpoint without the person being aware that you are letting him endorse your viewpoint. Doctors are not supposed to do that. They're supposed to be more objective and balanced in presenting the information to the patient so that the patient is able to make his or her own choices or decision, as the case may be. So the shift towards the patient-centered care also entails more thorough informed consent processes where doctors ensure patients understand all treatment options, risks, and benefits. And this is supposed to allow them to make fully informed choices. But then somebody will ask a question, having a doctor who has to deal with so many patients, do you have like the luxury of time to meet these legal standards? What do you think? Just one person, no, two. Okay, no, maybe we'll come back to this again.
Yeah, so I don't think it is feasible under the circumstance, because if you look at the ratio of doctors to patients right now, it doesn't even afford the patient the opportunity to even get counseling. So you have to rush them so that you'll be able to see many more patients. But I don't think it is feasible under the current circumstance until such a time that we increase the number of physicians that will be attending to these patients. Then I think the law can fight to the full end.
Okay, right. So the other thing, which other upshot from the paradigm shift from medical paternalism to patient-centered approach or therapeutic alliance, flowing from the Montgomery and Lagnacher, is that empathy and holistic care is actually called for. So doctors are supposed to appreciate that when it comes to medical treatment, it's not just about the physical symptoms. There are other things like social and psychological or even emotional dimensions. Like you take some patients, for example, let me get, especially those who are into, do you have a urologist among us? Those who are into urological practice. When it comes to, let's say, prostate management or treatment, sometimes you need to do the surgery, and you get a patient who said, okay, if I'm going to do surgery and it will affect my ability of sexual enjoyment or performance, okay, then I'll not do it. Maybe from a clinical point of view, that may not be wise. But from the patient's emotional or well-being point of view, that is what he wants. And that is the point we are talking about, that doctors should, within this paradigm, appreciate that medical treatment impacts the patient beyond the physical symptoms. Some other aspects like emotional, psychological, and social dimensions of health. So doctors should listen to patients' concerns, should encourage patients to share more. And each patient is unique. So we have to avoid this one-size-fits-all. So what happened in the Montgomery and Lagnacher? You look at the decision, but what was actually the facts? Sorry. Mrs. Nadine Montgomery, she was a diabetic woman of a small stature, and she was under the care of Dr. McLean during her pregnancy. Now, due to her diabetes, there was a 9 to 10% risk of shoulder dystocia during vaginal delivery, a condition where the baby's shoulders become stuck and poses a serious risk to both the mother and the child when it occurs. So mind you, unlike Sidawi, where there was a less than 1% chance of the risk, here, the risk of shoulder dystocia, if you did the vaginal delivery, was 9 to 10%. Now, Dr. McLean did not inform Mrs. Montgomery of this 9 to 10% risk, believing that disclosure might lead her to opt for CS or cesarean section, which the doctor deemed unnecessary from a medical perspective. Now, during the vaginal delivery, now this time the CS was not done. So during the vaginal delivery, shoulder dystocia occurred. And this brought about severe complication. And the baby born suffered from hypoxic ischemic encephalopathy, which brought about the cerebral palsy, or what we call the Down syndrome, so to speak. Now, Mrs. Montgomery eventually brought an action against the health board and argued that the doctor's failure argued that the doctor's failure to inform her of the risks deprived her of the opportunity to make an informed decision about her mode of delivery. So the mode of delivery had two options: to do the CS or to do the normal vaginal delivery. And she is saying that if I have been warned that if I opted for vaginal delivery, there was a nearly 10% chance of this shoulder dystocia, I would have probably not opted for vaginal delivery. I have gone for CS. And because I was not told, I have been deprived of this opportunity. And for that matter, I have a case against him. So the UK Supreme Court had to deal with two critical issues, among others. What constitutes a doctor's duty of care in disclosing risks to a patient? And two, whether the doctor's failure to disclose the risks of shoulder dystocia amounted to a breach of that duty, making the health board liable for negligence. So as we have seen already, eventually, the UK Supreme Court gave judgment in favor of the woman, Mrs. Montgomery, and held that doctors have a duty to ensure that patients are aware of all material risks involved in the proposed treatment, along with any reasonable alternatives. And the court pointed out that it is the patient's right, not the doctor's prerogative, to determine which risks they are willing to accept. So let's pay attention to them. That is why I said that this patient-centered paradigm actually requires that doctors should appreciate that medical treatments have impacts more than just the physical symptoms, with some other things like psychological, social, and emotional dimensions of health. And that is why it is the patient who is the best judge regarding what risks should be allowed to be run or which risks should be avoided. And the Supreme Court overruled the application. Please, this class, in terms of your contribution, is interesting, but you are very you are non-cooperative when it comes to basic discipline. Hmm? If you keep doing this, I will let all of you be coming physically to the classroom wherever you are in the country, and there'll be no online. I'll not even allow the classroom to be streamed online if you don't want to follow the discipline. If you want us to have online effectively, you have to obey the rules. Not until you're allowed to speak. Your mic should be off. I should be the only person speaking all the time. Otherwise, you get a disorder in the class. Yeah, so as we have noted, eventually the court overruled application of the Bolam test and effectively embraced what we will call informed consent. And the court said that doctors must take reasonable care to ensure that patients are aware of any material risk involved in proposed treatment. So here might do, instead that way, it was even less than 1%. But here, 10%. The court said that no, you must actually make the disclosure. Discuss any reasonable alternative and risk associated with those alternatives. So how do we know the materiality of the risks? Because the court said that the patient should be aware of any material risks involved in the proposed treatment. So we need to question the materiality of the risks. A risk is material if a reasonable patient in the patient position would likely attach significance to it. The doctor is or should reasonably be aware that the particular patient would likely attach significance to it. So that way, the risk is material and it should be disclosed. So here, as you notice, we're using the reasonable patient approach rather than the reasonable body of medical opinion, as Bolam told us. So now there has been a shift from power has been taken from the doctors down to the patient. Under Bolam, it was the technical people who were supposed to decide whether certain risks are wet or, they need to be disclosed. Are they clinically significant? Now, under the new paradigm in Montgomery, power has come to patients, so to speak. Now, it is a reasonable patient who is supposed to make the decision whether he or she should be told a particular risk before he or she can give the consent. And the court said that, yes, if Mrs. Montgomery had been told the 9 to 10% risk of the shoulder dystocia, she would have opted for cesarean section. And in the court's view, in making a determination as to what risks should be disclosed, it's not solely a matter of medical expertise. And if you remember our friend Ian Kennedy, Sir Ian Kennedy in his reflections and treatise seems to be making this argument. And this argument, of course, he made the argument in the early 80s. It took several decades for it to sink in to the apex court in the UK for them to agree in the sense that there are a lot of decisions within the doctor-patient relationship which are not essentially one requiring medical expertise, but some other things which the doctor is not necessarily the best judge. It's the patient who is the best judge because about the patient's life. The patient is going to live with it. It's going to, even if the patient is going to remain alive, it's going to affect the patient's quality of life choices, and various life functions and performances. And that is why he or she should make the decision. Yes, Regina, your hand is up. Let's hear you. Regina, your hand is up. You can speak now. Okay. No, we'll be finishing soon. The time is up. Yeah, you read.
My lord, it was a legacy hand. Apologies.
Legacy hand. Okay, I like that. Okay, so just before we go, let's say a few things quickly about other healthcare professionals. So we like to talk about the pharmacists. Pharmacists and then the patients. What are their ethical and legal responsibilities? So pharmacists. Yes, pharmacists have a role in educating patients, and that is very important. They should help patients to understand their medications, including proper usage, potential side effects, and interaction with other drugs. So pharmacists are supposed to help the patients with all this. It's not just enough that the patient has brought the prescription from the doctor, and then you just look at your shop or your stores, and then you just bring the medication. Take 3 times a day, morning, this and that. No. If you are doing your work properly, if the drug is likely to have an adverse interaction with some other things, you need to bring it to the attention of the patient. So the pharmacists are supposed to be like the bridge between physicians and patients, particularly when it comes to safe and effective medication use. Some patients, for example, there's something called this cis GPD or something. Is it something like that? Is this cis is it GPD or I think there's a certain
XPD.
Okay, good. G6PD, good. So there's a certain condition like that, and if you are one, understand there are certain types of drugs which should be avoided, or certain active ingredient and so on. So you, the pharmacist, if you are doing your work well, you need to also find out, are you aware whether you are G6PD and so on? If the person says yes, then you should be mindful of what's the do's and don'ts regarding the drugs. So your key responsibilities will basically include providing clear instructions, explaining how and when to take prescribed medications, and then you highlight the importance of adherence to the prescribed dosage to avoid underdosing or overdosing. You tell us that if you miss your drug time, you should tell the patient, if you miss the drug time, you don't have to take a double dose to make up for the one that you mix. The patient will think, oh, if I miss it, then this time let me take a double to make up for the one that you need to explain it to the patient. The patient does not have the knowledge. So it's not enough. So if you look at it, it's a whole team effort. It's not only the physician who is making the prescription, but you, the pharmacist, you've also got a big role to play. And that is why when it comes to clinical or medical negligence, it becomes a bit more nuanced and complicated. Sometimes the fault may not be coming from the prescription. The fault may be coming from probably even from the dispensing of the medicine by the particular pharmacist involved, as the case may be. Yes, it also includes responsibility. Also include educating on potential side effects. You have to let the patients know about the common and severe side effects and advise them on what symptoms necessitate immediate medical attention. You have to tell them that if you should see this, then don't delay. You have to come back or seek the nearest hospital and get assistance And the pharmacists here, I'm not sure that you do. I'm not talking about you, but I'm talking about the industry. I don't think they do all this all the time. Yes, can we get just one response from anybody from the industry? Okay, the responsibility also include monitoring drug interactions. You talk about that. Patients should be assisted to understand possible interaction between prescribed medications and over-the-counter drugs, herbal supplements, and also food. These are very important. The patient may be having maybe over-the-counter drug he or she has bought and be using it on routine basis, and now a prescription is made. You get the prescribed drug, but there may be an adverse interaction between over-the-counter drug and what has been prescribed, but the patient is not aware. And you don't tell the patient, don't ask the patient if the patient is taking any medication. So if you are doing your work well, you ask the patient, are you taking any medication at the moment? Then you have to ask what they are. And then based upon your professional and technical knowledge, you'll be able to establish whether there's any risk of adverse interactions. And the herbal supplements too, that's also a big deal, especially in a country where herbal preparation is supposed to have the cure for several health conditions. The same herbal preparation, which would enable women who are trying to solve infertility problem, get children, it's also supposed to solve a problem for those who are suffering from impotency or premature ejaculation and things like that. And then at the same time, it's supposed to also be a solution for those who have poor eyesight. It's supposed to be a solution for those who have bodily pains. So the same herbal preparation, can you imagine that? So that should tell you that if you are going to give prescription to, you are going to dispense a prescribed drug, you need to find out whether the patient is taking any herbal supplements so that you're able to give the right advice. Or even if you let the patient suspend the herbal supplement for the period that he or she is taking the prescribed medication. Of course, pharmacists also serve as advocates. You advocate for patient safety. How do you do it? If you have a very good pharmacist who is doing his or her work well, if you even have like a doctor who is not doing his work well, or a substandard practicing doctor, the pharmacist will be able to save a lot of lives because you'll be able to identify and any errors in prescription. Sometimes the doctor has given wrong dosage, and that dosage, overdosage, underdosage, and so on. Or some doctors, either they didn't pay attention to their the pharmaceutical aspect of the training of the medicine, pharmacognosy, and so on. They be doing harmful drug combinations. So a pharmacist will see it and they will say that no, this is not right. And I suppose that we get a clash sometime between the proper qualified pharmacists and then the various physicians or doctors. So they get that kind of professional rivalry. And in the end, it is a patient who suffers. Instead of you collaborating to see to the welfare of the patient, the doctor wants to prove that I am in charge. The pharmacist want to prove that your knowledge about drugs is very limited. And for me, my whole professional career and technical training about drugs, and I know more about drugs than you. So what you have done is wrong. Do you get that situation happening? My students are not sleeping. Okay. Okay, so let's say few things. We also have a problem.
Were disabled.
Oh, right. Okay. Just before we say a few things about nurses and then we leave, with respect to the pharmacists, we have ethical problems too, especially. We've discussed them already. Conflict of interest when recommending medications or brands. And it arises because of financial incentives or employer policies or personal gain, uh, which you are allowed to influence your professional judgment as a pharmacist. And ultimately, that will compromise the safety of the patient. So, how to deal with the pressure from pharmaceutical companies? Pharmaceutical companies, for them, they're interested in getting their products on the market and being patronized. So, they may give you various incentives like bonuses, commissions, or you've brought this particular quantity of drugs. If by the end of the second quarter, about 50% of the quantity that you brought is actually gone, we are going to give you so much. So, your interest. So, if you look at these things, these are very serious matters. But the patient is not aware of all these, undercurrents, as it were, operating in the clinical and then the facility, the setting. The professionals there are facing temptations of their own, personal gains, including money or sponsorships and so on by pharmaceutical companies. You may also have some pharmacies or some facilities which promote specific products or brands. And pharmacists are encouraged to put more priority on the company's profits over and above other suitable options for the patient's well-being. So somebody said that we have generic products. For example, there are a lot of generic drugs, India, a lot from India, and the active ingredients are essentially the same. But because the big brands, they have more money, and then the facility has a certain trading agreement with them, the management will say that don't ever tell anybody about uh, you know generic alternatives which are also available if they cannot afford those brands. So these are some of the things we've discussed this already. So in the end, patient trust is at stake, isn't it? Because patient relies on pharmacists to act in their best interests. Pharmacists are supposed to serve as a check on the the accuracy of the work of physicians when it comes to prescriptions and so on. But where those who are supposed to serve as a check are also pursuing some other interests, then the patient will have to look up to the Almighty God for safety and protection. Or human beings are actually disappointed. So to address these ethical challenges, we need to have strategies like transparency. If you're a pharmacist, you must disclose any affiliation you have, any financial incentives, or other employer policies that may influence recommendations. There should be that transparency. Provide patients with unbiased information about all available alternatives, including generic medications. We have pharmacists in big facilities. They have also set up their own, like drugstores, in the high street. So you go there and you tell them, oh, this particular brand is rare, it's out of stock, but we have another brand which is even better than what the doctor prescribed. You can get one at this pharmacy at the Asylum down this particular street. So the pharmacist is putting his interest over and above his professional, ethical obligation. Good. Yeah, so you have to also adhere to ethical standards. In all this, the way at the end of the day, it comes back to personal integrity. Because we talk about all this, you, the human being, you are the best person to say that you're not going to fall for a wrong thing. And this applies not only to health professionals, to all professionals. You come to us as judges, as lawyers. You are supposed to know that you have to do the right thing, you have to avoid the wrong thing. You can have a lawyer who is so unethical that he even crosses carpet to his opponents to go and get favors from his opponent in order to undermine the case of his client. It happens. It may shock you, but it happens. Just as you may get unscrupulous court officers who may also want to get favors in order to give certain advantages and so on. So we talk about all this, but ultimately, the human being who is operating the particular trade or who is the professional will have to ask himself or herself, do I want to do the right thing or do I want to do the bad thing? There's also a need for continuous education. And of course, there's also a need for advocacy for systemic change. Okay, where there's a breach, I think the time is fast spent, but let me just take maybe just 5 minutes and then we will end. So where pharmacies, for example, you breach your legal obligations, you can also be sued for negligence. You could be sued for negligence. Let's say that you recommend a drug due to financial incentives and the patient experiences harm. You can later on be sued. So it's not only the doctors who can be sued, you can also be sued. Of course, you also have the regulatory sanctions. So we have the Pharmacy Council. If you look at the Health Profession Regulatory Bodies Act at 857, and you can face a disciplinary action by the council. Of course, you can also be sued in other areas of the law. So just before we go, what about nurses and allied health professionals, their relationship with the patient? All the things we have said, as lawyers will say, apply mutatis mutandis or with necessary modification to nurses and other health professionals, as the case may be. So we are not going to belabor the point. All the things that we have said, they apply essentially to them. But the point to note is that there's what we call the collaborative healthcare models. If you look at medical or healthcare practice in modern times, it's based on team. It's a team-based approach where various professionals, physicians, nurses, pharmacists, phlebotomists, and so on and so forth, they all collaborate to deliver integrated care to patients. So doctors, nurses, physiotherapists, social workers, and other specialists work together to achieve holistic treatments with their various professional background so as to deliver the needed care for the patient. So it's a team-based patient care. And in that respect, each professional role is recognized and valued. It's not only the doctor. No doctor can work alone. And the doctors here will agree that without other professionals, their work will not be meaningful and will not be safe. So doctors may handle diagnosis and treatment, while nurses provide ongoing care. Physiotherapists support mobility and rehabilitation. Social workers address psychosocial needs. So here you see that various professionals are playing the various roles so as to deliver comprehensive care. That means the multiple dimensions of health for the patient. So there's a need for communication and respect. And that is why I find it strange. If you get professionals in a team who are at loggerheads, then you are going to kill the patients you are looking at. There should be that collegiality and that openness, because you need to share information so that you'll be able to serve the patient well. Of course, there are challenges and ethical consideration, conflict over professional opinions. We've talked about some already, especially between the doctors and the pharmacists. Okay, so we will draw the curtain down here unless there's a major question which needs to be answered before we go.
My Lord.
Yes.
Yes, I want a clarification.
Mm-hmm.
Having cited the Bullard case and then the Montgomery case,
Yes.
all being cases of the UK Supreme Court,
Yes.
may I solicit from you a Ghanaian position? Because those rulings, as we know, are just persuasive.
Yeah.
So going through the Ghanaian act, the act itself, what the patient charter and the Ghanaian position.
I think the Ghanaian position is, as you rightly stated, in the patient charter based upon the Section 167 of the Public Health Act. And we have moved towards what we call the informed consent. So essentially, we agree with what Montgomery is saying. And interestingly, our law was 2012. Montgomery was decided in 2015. So one would argue that even before Montgomery, departed from Bolam, we had already moved on. We had already embraced informed consent. We had already embraced the fact that it's no longer medical paternalism, but it is therapeutic alliance, collaborative partnership between the patient and then the healthcare professional. And the patient at the C schedule of the Public Health Act actually speaks to that. So that is our position. And then if you look at there are some few cases which have come up, which will be discussed in the few medical negligence cases, but we are not doing the more practice or negligence discussion now. That is why we don't cite all those cases, Asante Kremo, the Jan, and then the recent 37 hospital decision. So we discuss them as cases for medical negligence, but on this occasion, we're just looking at the doctor-patient relation. But because those cases were fought just as normal clinical negligence, the courts did not actually come out in a more focused discussion of the kind of discussion that we see in those cases that we're dealing with, where they try to focus on what is the nature of this doctor-patient relationship, but we come to them. Yes. Mm. Okay, then have a good night.